Yes, I was quoted in the Washington Times in its headline today. Let's discuss in just a second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, best-selling author, and most importantly, proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the Second Amendment like we love it here. Okay, folks, I just want to show you, I got up early because I had to do the Steve Gruber show in Michigan. I love doing Steve Gruber's show in Michigan. He's great. He's great on guns. He's very smart. Love his show. And I was just doing it this morning, so I got up early. So when I got up, as soon as I got up, I realized on the cover of the well, I don't know if it's on the cover, but certainly on the homepage of the website, I'm not in Washington, so I don't know what's on the cover of the paper itself. But on the good news front, I noticed that actually I'm quoted in the headline of the Washington Times this morning talking about the tsunami of Second Amendment litigation that we can expect to see coming forward thanks to the NYSERPA versus Bruin case. So I thought I would just talk for 2 minutes about the nature of this article and my views that were expressed in the Washington Times. I'll also put a link to this Washington Times piece down below. Obviously, as we've talked about on this channel, because you knew it first, in NYSERPA versus Bruin, this is really going to open up the floodgates of lawsuits involving the Second Amendment. And not only the lawsuits. Remember, the lawsuits are a means to an end. We don't care about the lawsuits per se. We care about winning lawsuits. We care about changing the law. And that can occur in many different ways, including through lawsuits, of course. But by changing the law, you want to change it in favor of the Second Amendment, in favor of the Constitution, in favor of civil rights. And one of the points I wanted to make in this Washington Times article, I want to make to you, that I also made in the Washington Times article, is I do think it's fair to draw an analogy to some degree between what we're seeing in places like New York and California, this sort of massive resistance by these state governments and possibly from local governments too, we'll see, to the Supreme Court's decision in NYSERPA versus Bruin. And the point I made in the Washington Times, and I'll read it to you and then we'll talk about it. I said that just as in Brown versus Board of Education, just as Brown versus Board of Education was a landmark moment in dismantling the Jim Crow regime of separate but equal and in ensuring civil rights, so too is Bruin a landmark case that will pave the way for fuller vindication of our civil rights under the Second Amendment. So that's the quote I gave to the Washington Times, and they published it. And I truly believe this is the case. You see, it seems to me that New York and California, maybe some other states, are trying to civilly resist what the Supreme Court is doing by passing the laws to try to get it end run around the court. And this was very similar to what happened in the 1950s and 60s, where you had certain southern states that wanted to embrace the Jim Crow era. Now, what the Jim Crow era was in the South, of course, was the notion of separate but equal, based upon a case called Plessy versus Ferguson. And Plessy versus Ferguson was a Supreme Court case from the 19th century that said that as long as you had separate but equal facilities, separate but equal restaurants, separate but equal voting, separate but equal public facilities and accommodations for African Americans on the one hand and whites on the other hand, that was constitutional under the 14th Amendment. The 14th Amendment, which was enacted with the 13th and 15th Amendment after the Civil War, provided for the equal protection of law, known as the Equal Protection Clause. And under Plessy versus Ferguson, they said that the 14th Amendment Equal Protection Clause was satisfied as long as you had separate but equal government and public accommodations in the South. And that was the law until the 1950s, where you had a series of cases, most famous of which is a case called Brown versus Board of Education by the U.S. Supreme Court that says that Plessy versus Ferguson is overruled and that separate but equal is unconstitutional, and really African Americans and whites have to basically be allowed into the same place. Segregation is no longer constitutional or allowed under the 14th Amendment, and the states in the South that embraced the Jim Crow era, which was based upon the separate but equal concept, all this had to go away under the Constitution. The Supreme Court was fully behind this, but the southern states resisted in various ways. They wanted to maintain segregation to keep, the African Americans away from the whites and vice versa in public accommodations and public facilities. And of course, the Supreme Court continued to fight on behalf of the African Americans that wanted, all the remnants of separate but equal to go away. And we know the story is that obviously the Supreme Court was ultimately vindicated over those southern states that had embraced the Jim Crow laws. So I do think there's a little bit of analogy here, because it seems to me that the Supreme Court has stepped up in 4 separate cases since 2008: Heller, McDonald, Caetano in 2016, and now Nysurper versus Bruin to say that the Second Amendment is a fundamental, I repeat, a fundamental right. It's a fundamental constitutional right to keep and bear arms, and it must be respected by all states and localities, including New York and California. And New York and California are very upset by this because they think, in my opinion, that they are above the Constitution. They're more important than the Second Amendment. They're smarter than the Supreme Court, and they don't have to follow its rulings, and they're trying to use creative lawyering to get around it. But I don't think it's necessarily going to work because, remember, New York and California can be thwarted at the lower court level. And unlike in the past where maybe you could argue it was debatable, it really wasn't debatable, by the way, but you could argue it was debatable. Now you can. The Supreme Court has made it very clear whether it's a proper test, which is you read the text of the Second Amendment first. And then, of course, to the extent there's any questions about what applies to it, in terms of gun regulations, you look at the history at the time of the founding to see the relevant history. If there's any analogous gun control laws, which, of course, there really weren't any gun control laws at the time of the founding. Technically speaking, you could argue there was two types. One is that you could keep guns away from dangerous people who are the equivalent of back then Indians, as Justice Kennedy said in oral argument Heller, or Tories who were really the enemy in the war for independence. Those were the two types of quote unquote dangerous people. Arguably could keep guns away from at the time of the founding. And relatedly, there were fire codes, which again were not police codes. They were not gun control codes. They were fire codes in places like Boston that said you could not store too much black powder in the city because, again, the whole city was made of wood. And because the whole city was made of wood, if you basically if the black powder caught fire, it would burn the entire city down. So the powder was generally stored outside the city in these big brick buildings, if you will, to make sure that the city didn't get burned down. But that was not gun control legislation. That was fire code legislation. And the Heller Court actually specifically said exactly what I just said in 2008. Okay, so yes, we're going to see this massive resistance that we saw back in the 1950s against the Brown versus Board of Education's decisions by the Supreme Court. I think we're seeing that in New York and California and other places, trying to resist the advancement of the right to keep and bear arms, which really should not be an advancement because the Second Amendment is recognized as a robust constitutional right all across America. As you know right now, 25 states are already allowed for permitless carry of firearms, meaning you don't even need a permit to be able to carry in 25 of the states. I'm sure that number is going to continue to grow. And although you're going to have this massive civil disobedience, this massive resistance by certain anti-gun states, of which I would say at most there's 6 of them, you know who they are: New Jersey, New York, California, maybe Hawaii, Maryland, although right now, based on what I'm hearing, Maryland and Hawaii are not going crazy like California and New York have gone. So let's see what happens in those states. Some of the states may do the right thing and follow the law and do what basically the Supreme Court indicated should occur. Again, just because a case cannot go back all the way up to the Supreme Court over the next several years, that doesn't mean that a lower court cannot enjoin or strike down as unconstitutional these gun control laws in places like New York and California. Lower courts do this all the time in many contexts. All cases don't have to go to the Supreme Court. So hopefully what we see in the tsunami of litigation, we see favorable lower court rulings that enjoin and stop these, what I consider in many instances, if not all, these unconstitutional encroachments on our Second Amendment rights as articulated by not just the text of the Second Amendment, but also by the Supreme Court's jurisprudence, which includes now the decision in Nysurper versus Bruin. Okay, I hope you learned a little bit something here today. I'm going to post the Washington Times article at the top of this, and I'll also put it in the community section. You can check it out there. And again, we'll see you soon here at the Four Boxes Diner.
Orders up. Table 2A.